second case on this morning's docket. That is case number 110468, State of Kansas v. Mullen. Counsel, why don't we wait until the crowd has left the courtroom? That way you're not distracted. We always like to advise counsel not to take it personally that the crowd has left before they started their presentation.
I'd actually prefer to do this with a smaller audience, so I'm okay with that.
Very well.
May it please the court, Joanna Labastida of the Appellate Defender Office for the appellant, Jordan Mullen. If I may, I'd like to request 3 minutes rebuttal.
3 minutes is granted.
Thank you. Admittedly, the two issues relate to each other. I'm sure you understand that, but the same case law I'm sure will be discussed with both issues, but I'd like to start with the second issue on appeal, if I may.
And with that in mind, would you mind giving the people watching on the computer about a 60-second factual overview?
Sure. A postal inspector in Kansas City came across what he believed to be a suspicious package. It was taped up on all seams, and it was coming from a state that has drug activity. So he called in a police dog to do a sniff on it, and it alerted. So he called the police in Johnson County, which is where the address on the package was to be sent. And the police there filed for an anticipatory warrant, and the triggering event on that warrant would be the successful controlled delivery to a resident. And the warrant also said if the delivery is not made, the warrant would not be executed. And so that same postal inspector, dressed in a uniform, went to deliver the package to this address, knocked on the door, waited for a minute, no one came to the door, so he left it on the doorstep. A few minutes later, my client opened the door and brought the package inside. The warrant was then executed, and the package was found on the counter unopened. After issuing Miranda warnings, they questioned my client, and he eventually admitted that he knew that there was marijuana in the package. He filed a motion to suppress at the district court level, saying that the controlled delivery did not actually occur because there was no hand-to-hand delivery, and therefore there was not probable cause for the warrant. I raised that issue, and I also raised an issue which I'd like to discuss, that even with that controlled delivery, there was not enough probable cause in the warrant for it to be valid. And that triggering event, we'd argue, was not sufficient for probable cause. No other evidence supported that. There was nothing about that location that had drug history. The residents that were listed in the affidavit, there was nothing about them having drug activity history. The address was correct, but the person who was supposed to be addressed on the label did not live there, according to the records. You couldn't really even tell what the last name was. I think Noah was the first name. So we'd argue that there was no indication that the police knew that my client knew what he was accepting.
Is that required for probable cause for the search warrant?
We would argue that there has to be some indication that a crime is being committed. That's what the statute says. And we'd argue that a crime can't be committed if there's no indication that the person accepting a package knows what's in it. And there was no other evidence to show that he knew what was in it. And in fact, the cases that the state cites to say that triggering event, the controlled delivery, is enough, I would argue actually supports my my contention, because
I'm sorry to interrupt, but isn't the probable cause required that a crime is being committed, not that your client is committing a crime?
Yes, except that we would argue, how can you know that a crime is being committed if no one at that residence knows they're accepting drugs?
Well, the police knew that there was a package with a substantial amount of marijuana in it that was inside the house, right? That's uncontroverted. Am I correct about that?
That's true, yes. And this is how the first issue and the second issue kind of relate. The cases that are cited by the state show some indication that the person accepting the package in the controlled delivery knows that they're accepting that package, or knows that there's potentially contraband in there. Each one, they're either the addressee of the package, or they ordered whatever was coming, child pornography or whatnot. So in State v. Hugaboom, the package was addressed to that particular person, that defendant, and the postal carrier confirmed that that person was the addressee. And then the warrant specifically said that an adult who willingly accepts that delivery. And we'd argue that that the warrant did not have that, in this case, did not have that level of confirmation that Mr. Mullen knew what he was accepting. In fact, another case...
Well, how do you distinguish is it Hogaboom or Hugaboom? That really stands for the proposition that the government need not provide additional independent evidence linking the resident to the criminal activity. It's the criminal activity itself that is the focus of the probable cause for the warrant. That's what it's the focus on the criminal activity, not the recipient of the contraband or whatever's
But I think those two
is part of the anticipatory warrant.
I think those two issues are related because, yes, drug dog sniffed on each package and knew that there was drugs in there, or indicated that there was drugs in there. But one package has his name on it, the addressee's name on it, and it's being delivered to a specific address. The second one, there's no indication that the person who's picking up that package is the addressee.
And again, they in Hugaboom, they specifically say that is not the component that's looked at. It's the nature of the criminal activity and the successful delivery to the residence, not establishing that there's a connection to the person that actually physically picks up the package and takes it to the residence, or if it's handed to them. That's not the focus.
Right.
And there's several cases also that follow that the state points to.
Yes, I understand that, but and that's why these issues kind of meld together, because our argument would be that probable cause for a crime being committed isn't shown in this case if you can't tell that the person who's accepting the package knows that there's drugs in it. And aside from him bringing the package in at this address.
Well, let's follow that hypothetical through. Let's say that the evidence became, after the search warrant was executed, the evidence became overwhelming that your client knew nothing about what was in the package, was a completely innocent bystander. A crime is still being committed, right? By somebody. Isn't there still probable cause to believe that a crime is being committed and that evidence of that crime was to be found in that location? I mean, how does that defeat the probable cause for the search warrant is my question. Just because your client might in fact have been innocent.
I actually ran through this hypothetical with some colleagues at work yesterday, and I would argue that the crime being committed occurred when they sent the package, and so the crime is not being committed at this location because no one knew that they were accepting those drugs. And so
all that's required is that the state demonstrate that it's likely, probable cause that a crime is being committed and that there's evidence of the crime at the specific location. And wouldn't that package of marijuana be evidence of the crime, regardless of where we sort of parse out where the crime was committed?
I'm going to have to stick to my position then,
Okay.
that the warrant, as it is in this case, did not supply enough probable cause for them to come in and search.
But if the target, I think where we're getting at, if the target of this investigation had been the sender, the person that packaged and sent it from California, and that would not preclude getting a warrant to search the package after it's delivered as evidence of the crime of having distributed marijuana from California, correct? I mean, you're not precluded from going in and searching for the evidence if you're targeting the sender.
I would argue that the police should not, at this point, have gotten a warrant for that house. They should have either confirmed that Mr. Mullen was knowingly accepting those drugs, or that he was accepting that package despite the fact that the addressee was not correct.
Well, we're not talking best practices here. I think what we're back to trying to answer Justice Stiegel's question is that the sending of the package of drugs from California was a crime.
Mm-hmm.
Do you agree with that?
I do, yes.
And in transit, a postal inspector became suspicious that this crime was occurring.
Mm-hmm.
Okay, and at this point, then can the law enforcement get a warrant, have probable cause to believe that that crime has been committed from the sender,
Mm-hmm.
and get a warrant to intercept that package wherever it may be?
Intercept that package in someone's home?
That's to search for evidence of that crime, even if an innocent person is involved. And your argument is, I think, that the residents of the residents
Mm-hmm.
have to be implicated before you can invade their Fourth Amendment rights. Is that what you're saying?
I'm saying that there should be more in the warrant, the affidavit, to suspect the people that are accepting that package, potentially unknowingly, that to invade their privacy, yes. And as I was going to say earlier, there's not necessarily a need for them to deliver that package. They could wait on that and gather more evidence that would support probable cause. But my position is, as this situation occurred in this case, there was not enough probable cause with that delivery.
If the package had just been delivered to a warehouse and there was nobody there to receive it, as Justice Stiegel was indicating, under that scenario, a crime is still being committed, correct? Once it's been, the marijuana has been put in a box, I think in Oakland, California, and put in the mail, there's probable cause to indicate a crime has been committed or is about to be committed.
Mm-hmm.
From that point all the way until it went to the warehouse. And while it's sitting there in the warehouse, are you saying that a search warrant could not have been obtained to open that up?
You know, I'm not sure I have an answer for that, because I just believe that there needs to be more on the person accepting the package, and
To charge them with a crime?
not
Or-
necessarily to
okay.
charge, but to even go in and search. It's a difficult situation, I understand. And so I'm not sure I have an answer that would satisfy this court other than what my answer has already been, that there needs to be more in the probable cause warrant to satisfy that.
What the real question is how, in my mind anyway, is how much nexus
Mm-hmm.
the occupants of the house whose privacy rights or Fourth Amendment rights are being impinged upon,
Right.
how much nexus they have to the crime that's being committed. I mean, that's a real question. And do we have any case law on that? In other words, can someone get a warrant? Can the police get a warrant to come in and search my house from top to bottom because they think my neighbor has committed a crime and there might be evidence? There's probable cause to believe that there might be evidence in my house unbeknownst to me. Is that okay? And,
No, I would argue that's not.
well, and why isn't it? Why doesn't it fit as Justice Stiegel says, the probable cause to believe that there's evidence of a crime in my house?
Mhm.
Say they have that probable cause, believe that, but I don't know about it, and it's my privacy being impinged upon to target my neighbor.
Right.
But do we have any cases that talk about the nexus?
All of the cases cited within our briefs all deal with situations where there is a nexus. And so it's even with the cases the state cites to say that that triggering event supplied sufficient probable cause, there is some indication that the person being searched knows or should have known that there were drugs in that package, even before they go in and search.
Is part of that equation that provides some evidence of the reliability of the address being a purposeful address?
Right.
I mean, for all we know, whoever in Oakland could have been high as they were addressing it and got the numbers mixed around.
That's correct.
And this package is going to a house, 3 doors down that they, because they flipped numbers, or 3 blocks away because they flipped numbers.
That's
Is,
right.
is that your point, that there has to be something more so that we have the reliability that just having a label on a box is actual proof that?
Exactly. And similar to your example, again, the state cited a case, State v. Buyer, where a package was delivered to a house and left on the porch, and someone else drove up, picked up the package, and drove off with it. And I mean, if they hadn't come 3 minutes later and the occupant of that house had brought the package in, you would have the exact same situation here, where there's nothing else to connect that house to drug activity, or even the occupants of that house to drug activity, yet the police would be able to bust down the door and search their house. So yes, I think there does have to be some other reliable information to connect a house to that drug box.
We have any more questions? I see none. Thank you, counsel.
Thank you.
Mr. Obermeyer, before you get started, I was just curious, are there any states that are not known for drug activity?
Justice Johnson, I do not know that.
Okay.
But I know we have to rely on what evidence the trained law enforcement officer knows, but the state does have a dog in this fight, unlike the previous case, in that this all started with the German Shepherd Franz, who alerted on a box containing what turned out to be 2 pounds of marijuana. And I think, as I understand the argument, there's 2 things. One, that all hand-to-hand deliveries are controlled deliveries, but not all controlled deliveries are hand-to-hand deliveries. And there are other ways to deliver that package to the residents. I wanted to follow up on one of the last cases that my colleague cited. I want to correctly pronounce it. It's State versus Buyer, not Buyer, that dealt with a controlled delivery of a package on a porch. The police were surveilling it, waiting to execute the search warrant on the residence. And the defendant comes along, takes a package off the porch and leaves, and then we have a car stop. They did not execute the search warrant on that residence because the triggering event for the anticipatory search warrant did not occur. Was there a crime that was in the commission in the process? And I think yes, there was a crime. Somebody had sent that package from California or from whatever state, and there was probable cause to believe that there were drugs in there based on the dog alerting. But I think where part of the maybe confusion is would require the court to look at the territorial applicability statute, and it used to be 213104. Now it's 215106, that basically says if any part of a crime occurs in Kansas, then that person can be prosecuted in Kansas. So can the sender of the package from Oakland addressed to Noah, last name unknown, to Kansas, can that person be prosecuted if we can find out who that person is in Kansas?
But does that give you the right to invade my privacy so that you can prosecute him? If If the sender just decides to send it to my random address with a plan that, like the Breyer situation, that, you know, my contact in Kansas is gonna be sitting outside my house and watching for that delivery and gonna grab it off the front porch before I get home from work. Would that, if by chance I'd been home and grabbed that package right away, my rights should be invaded?
Well,
Or should there have been a delivery where the post office or whoever, the contract deliverer, actually hands it to me at the door, confirms that I'm Noah and this is my address, and hands it to me? Should there at least be that?
well, in this case, there was no required signature for the package, which was something else that raised the concerns. But I think to answer your question, for you, sadly, yes. If there's probable cause to believe that evidence of a crime is in your residence, even if you're an innocent bystander, unknowing, that if there's evidence in that particular place, a search warrant can be executed.
So-
And we have, I'm sorry.
Your answer to Justice Luker's question is essentially answering Justice Johnson's earlier question, that from the state's perspective, there is no requirement to show any nexus whatsoever between the resident of a home and the crime for which the search warrant has been issued. Is that right?
That's right.
And so let me just, if you don't mind,
Sure.
I sort of, as we've been talking about this, can imagine a scenario where
Okay.
maybe even one step further than the package being delivered. Let's say there's a package of, everyone knows it's a package of drugs. There's a foot chase. The individual being chased runs down an alley, sees an open window, chucks the package into the window. Can the state then go get a search warrant for that house just because they know that a package was thrown in during a foot chase? I mean, there's absolutely no nexus whatsoever between these innocent residents of that home and the fact that drugs ended up in their house. Can you still get a search warrant?
Yes, but because there's evidence of a crime in that particular location, which are the two
And then that's all
requirements
that's required.
under the Fourth Amendment. Now, whether we would charge the owner, I mean, charging the owner of the residence or warehouse or Justice Luker is a separate issue, which, you know, requires investigating it. And my example in the brief was, well, let's say there's a dead body in a house and we have a search warrant for that. You're saying we can't go into the house unless we know who committed the crime or that the owner of the house was involved? That does not make sense to require that.
So it's just a constitutionally permissible risk that if you are the homeowner in my colleague's hypothetical who happens to have a marijuana grow operation in your basement that has not come to the attention of the authorities, and then someone runs by and tosses something into a window and the police get a warrant so they can come in and get what got tossed through the window and find your grow lab. Too bad, so sad for you. I mean, this is what my colleagues are getting at. Is
Right.
that it's possible that someone is conducting some other activity in their home that has not come to the attention of law enforcement, and that would be discovered.
Correct.
And they had a privacy right about that until the minute the package came through the window.
I guess
So
that would
that's
be
all
true.
constitutionally permissible. bottom
Yes,
line.
I'm not sure how they get in the basement in your scenario, but yes, I think that would be covered. And we have examples all the time where kids are, committing crimes, stolen iPads or phones or whatnot, and they're at the residence. Now, do the parents know that their kid has a stolen property in the house? Probably not. But does that mean the police can't go in and search because, well, we got to let the parents know before we could go in and execute the search warrant?
But still, there's a verifiable nexus to the location of that kid's. It's that kid's residence. I mean, that's a different situation than the at least potential that something could be so random that there's not a nexus of the crime, the location, other than the action of a third party outside that residence that has no proprietary or no privacy interest in that residence.
Well, I guess I would direct you to the Lawson case, Justice Luker, because under your previous scenario, what if the numbers were written down incorrectly. What if they weren't? And the Noah, who doesn't live at that residence, was the intended recipient, because if you're going to send 2 pounds of marijuana to somebody, you probably want to get it right where it's going. The Lawson case says that it doesn't matter. It just comes down to the evidence of contraband, which marijuana is contraband, or evidence of a crime, which is also evidence of a crime, at least as to the sender, not as to the recipient necessarily, in a particular place. And I don't think that offends the Fourth Amendment in that.
The additional evidence that you had in this case was that Mullen talked to the detective. I mean, you've got him picking the package up and taking it inside and all that, but then you've got the police approaching and saying, "Oh yeah, and I knew that was marijuana in there." I'm looking through our notes, and I didn't write it down here. The scope of the search warrant at the premises was to just retrieve the package, or was it to conduct a search for anything else in the house related to what? I don't have a copy of the warrant in my notes.
Right, and there was some discussion of that in the district court, because District Judge John Bennett said, I think you could absolutely go in and retrieve that package. His concern was with searching for evidence of drug
The computer,
deals.
looking into. I'm thinking
Right.
about, if somebody wants to prank somebody by mailing a certain amount of drugs. And
Right.
So, you're just some poor guy that gets this package, and now all of a sudden you're looking into the computer at the house or whatever. So, but what does the warrant say?
For the drugs, related packaging materials, related paraphernalia, and then it does go into records reflecting transaction involving illicit drugs, currency, cell phones, computers, which may contain tracking history and indicia of occupancy. So it did include that those other things that could be searched for, and not just the package, which was Judge Bennett's concern, but in this case, all they basically retrieved, I think, was the package. Mullen did not, his cell phone wasn't working or hadn't paid his cell phone bill, so that was a non-factor, but that was it. But so that's really not an issue for State versus Mullen in this case. It's really the probable cause to seize the package, which is what they did seize, and that doesn't necessarily guarantee that somebody's going to be charged with it. The other people who lived there with Mullen were too busy attending college classes to come in and talk to the detectives about it. If an elderly grandparent brought in the package, or a young kid, that doesn't mean they're going to be charged, because you have to knowingly possess something to be charged with a crime. And I think there was a U.S. Supreme Court case from last summer that talked about drug possession and knowing that you possess it. And the Kansas Code requires a knowing possession of property. So just some unwitting person bringing the package into the house is a separate issue, because it's probably not going to get them charged with a crime, versus whether or not there's probable cause that their number one was contraband, number two in a particular place.
But we're not talking about charging with a crime. We're talking about being protected from unreasonable searches and seizures. I mean, that's what we're really talking about. You going through, my dresser drawers because a package was misdirected or whatever.
Well,
And, even if you're not charged with a crime, doesn't mean you haven't suffered indiscretion, at least.
that would be true. I mean, as I understood their argument, it was you had to connect the person in the residence with the crime to charge them. As to the scope,
To establish probable cause to get the warrant.
correct.
Is what the point
That's
is,
what I
not to
understood.
charge them, but the focus here is on the warrant, and what establishes a sufficient basis to get the warrant. Not ultimately what happens, I suspect. It's not really the issue.
Right. and as the case, as I said earlier, with kids who commit crimes and the parents are unwitting, it happens.
That's a big difference, because the child that resided there, you would be arguing that their consent to search the house was valid, wouldn't you? If the police came and says, we think your parents have some marijuana, can we search the house? You know, if you have the authority to consent to a search, that makes it a whole different scenario.
I don't think a kid can consent to search mom or dad's safe or someplace where they don't have access anyway. I mean, I know there's cases on that, but general areas of the house they could. But I mean, I guess the takeaway is the contraband or evidence of a crime is the nexus to the residence, and sometimes there are, you know, unwitting people who own the residence, and that happens. I would think that would quickly be discerned by the people executing the warrant.
It sounds like, if I could just restate your argument so I understand it, you're saying probable cause for a search warrant does require a nexus, and it's a nexus with a location, not with a particular person. I mean, in other words, there was a nexus here between the drugs and the home. Everyone knew from law enforcement side that the drugs were in the home, and that's the nexus. Is that your argument?
Yes, that is my argument. It's the package in the residence that is the nexus. I don't think I have anything else other than that I think the district court and the Court of Appeals got it right. Judge Bennett ended up saying that I'm not going to suppress that package. They have got to go back in and get it. The magistrate knows it went in there. He's going to allow them to go in and get their package. So under this supervised delivery or controlled delivery, that the warrant was proper. We already lost the issue on the waiver of jury trial, so we're going to have a trial on stipulated facts, I guess. And then even getting to the sufficiency of the warrant, I argued this raised for the first time on appeal, just because I've had prior search and seizure cases raised for the first time on appeal, and we can't call the officer to say, well, what did you go through to execute this warrant? Did anybody review it with you? Did you rely on it to even get to the good faith exception? So we're kind of hamstrung when that happens. But at any rate, on the search and seizure issues, the state would ask you to affirm the Court of Appeals decision. Thank you.
Do we have any further questions? Thank you, counsel. Reserve 3 minutes for rebuttal.
I just wanted to clarify something on the Lawson case that the state discussed with you about the nexus to the activity. In Lawson, the package was addressed to Lawson, and he signed for that delivery. So we would argue that there was a nexus of that package of drugs to the defendant. And I would argue that the nexus it's not for the house. It's for the people that would be accepting those drugs. Other than that concludes my remarks.
Just one final question. Is that why you think a hand-to-hand delivery is important, or is there some other reason why hand-to-hand delivery is important?
The hand-to-hand delivery gives the person accepting that package the opportunity to not accept that package.
So
Noah doesn't live here. I don't know who that's for.
Right. So it's establishing a nexus to a person. That's why, from your perspective, the hand-to-hand delivery is important.
Yes.
Okay.
I could go into that hypothetical that you discussed about throwing a package into a window, but I think I'll probably just talk myself in circles. So I'll leave that. Again, that concludes my remarks.
Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement